Section 17, Power of controller to make order respecting dating of application. We had already seen with regard to an application, there can be two types of dating. They can be post dating, wherein an earlier date is given up for a later date, or it could be anti dating, where a later filed application gets the priority of an earlier filed application. The easiest example for anti dating is when a divisional is filed, the divisional gets the priority date of the parent. It's a clear cut case of the divisional getting the date of the parent. This is an anti dating in the sense that the later filed application gets the priority of an earlier because the disclosure is the same. Post dating, when you file a provisional and you withdraw the provisional for whatever reason, you file a provisional, you withdraw the provisional and you file a complete. So, the complete does not get the priority of the provisional because the provisional is withdrawn. In that case, the earlier date is given up and the invention gets the date of the complete. So, it gets post dated, because the idea of filing a provisional was to preserve priority, but now if you have withdrawn it, then there is no point in claiming that priority because you have withdrawn the application, it is not there in the system. So, see, these are the two cases where the date of priority can either be antedated or it can be post dated. Antedated, we understand it as divisional application. Post dated, one instance of post dating is where a provisional is filed and the priority is given up, it is withdrawn, the provisional is withdrawn. So, the only priority will be the priority from the date of filing the complete. Now, there are some powers the controller has with respect to dating. 17(1) states that subject to provisions of section 9 specifically refers to post dating, at any time after filing of an application and before the grant of the patent under this act, the controller may, at the request of the applicant made in the prescribed manner, direct that the application shall be post dated to such date as may be specified in the request and proceed with the application accordingly. So, if a request is made by the applicant saying that I do not want my earlier priority, I want the priority from a later part, it is called post dating. It is done voluntarily for whatever reason, the disclosure may not have been perfect for whatever reason, or it is difficult for the applicant to show fair basis, it is difficult for the applicant to show because the disclosure was not good for whatever reason, or they do not want any disclosure they made in the provisional to be later be published, whatever be the reason, the applicant, and there is a risk in post dating. The risk is from that time till it is post dated, if there is going to be any intervening prior art that can affect the novelty. There is always a risk in post dating because you are shifting the point of priority from an earlier date to a later date. So, there is always a risk accompanied by that, and risk may be there, it may not be there. The risk could be in the way of an intervening prior art. Under 9, if a applicant makes a request in the prescribed manner, it shall be post dated. Once it is post dated, for all practical purposes, the date of priority will be from that date. Date of priority will be that date. Date of filing the application, if it is date of filing the application, we already mentioned, if you file for the first time, if you file a complete, then the date of filing the application is the priority. Then we do not use the word priority, we just say date of filing because that is the time at which it starts. So, that is an easier terminology, date of filing, there was nothing filed before, so we say date of filing. But if you file a provisional and then follow it up with a complete, we do not use the word date of filing because date of filing may mean two things, then we use the word priority date. So, the priority language comes in, if you saw the priority rules in section 11, priority language comes in when there is an earlier disclosure and a later claim. So, if the claim and the disclosure are in one go, we refer to the date of filing. And in international applications, you cannot file an international based on a provisional. We saw that it is a requirement that you file the complete. So, in all that you will find the language date of filing. Date of filing is the date of patent, date of filing. So, date of filing because it comes in one go. There is a proviso to 17(1). provided that no application shall be post dated under this subsection to a date later than 6 months from the date on which it was actually made or would, but for the provisions of the subsection, be deemed to have been made. Now, the post dating cannot happen for more than 6 months. So, if you plan to post date it, there is a timeline. If you file an earlier application and if you want to post date it, the post dating has to happen in the context of section 9. So, remember, post dating can be in the context of section 9, it could also be beyond section 9. In the context of section 9, section 9(4) talks about post dating, where a complete specification has been filed in pursuance of an application for a patent accompanied by a provisional specification, that is a provisional followed by a complete, or a specification treated by virtue of direction under subsection 3, that is the purported complete, we had already dealt with that, as a provisional. The controller may, if the applicant so request, under section 9 the post dating is done at the request of the applicant, so request at any time before the grant of a patent, cancel the provisional and post date the application to the date of filing of the complete. Now, this cancelling or this request for post dating has to happen within 6 months of filing. So, 17 we get that the post dating under subsection to a date later than 6 months from the date shall not be allowed. So, the post dating can only happen within 6 months. We need not look at what is the logic of 6 month period. We can assume that if post dating is allowed for a period for many years, one, it cannot be allowed beyond 12 months because the provisional has to be followed by a complete within 12 months. We can understand that 6 months may be a period within which there may not be substantial intervention by prior art. That is one understanding, I mean that is one assumption we can make. 6 months period is given so that in any field there may not be any intervening prior art, but in some cases there can be, but we can understand a timeline to say that the post dating has to happen within 6 months from the date of making the application. 17(2) states that where an application or specification including drawings or any other document is required to be amended under section 15, the application, specification or other document shall, if the controller so directs, be deemed to have been made on the date on which the requirement is complied with, or where the application, specification or document is returned to the applicant on the date on which it is refiled after complying with the requirement. Now, this is not in the context of provisionals, rather this is after a complete specification is filed, because section 15 comes into play only after the complete specification is filed. Now, in section 15, as you know, section 15 comes into play when the controller is unhappy with an application. He finds that there are reasons to reject it and he asks the applicant to make certain amendments. The applicant makes certain amendments and refiles it. Assume that the invention is disclosed earlier, but based on the objections, another part of the invention is for the first time included based on the controller's objections. So, that part which was included based on the controller's objection, that disclosure happened for the first time. You cannot now claim an earlier priority on that. So, that disclosure, when you put into the patent office, it gets the priority date from there on. So, in a sense there is post dating here, because whenever you file an amendment based on an objection from the controller and you introduce a new matter, when you introduce a new matter, then your priority is going to change from there. For instance, there are 10 claims filed in an application. The controller raises certain objections and all the claims have now to be, the controller is not willing to allow even one claim in it. So, based on the objection, in a section 15 proceeding, the applicant drafts a new set of claims completely different from the 10 which he had filed, and he also makes appropriate amendments in the disclosure. Now, all these new claims will take a date different from the claims that were filed in the first instance, because these claims were not there. So, the dating of this claim will be different from the date of the claims that were initially filed, because all those claims were rejected by the controller. So, the claims that were filed later will take the date on which it was filed. That is what the language says, being deemed to have been filed on the date on which the requirement is complied with. The controller feels that the 10 claims cannot be granted, the 10 claims have to be amended, say they were amended. So, it will be deemed to have been made on the date on which the amendments were filed, if compliance was through amendment, or if a document was returned to the applicant, if the controller returns the document to the applicant on the date on which it was refiled after complying with the requirement. Say form 1 was not complete, or form 1 the information was deficient and it was given back to the applicant. The applicant fills those details and files it back, then the date of filing is the date on which he complied with the requirement. It won't be the date on which he initially filed. So, ideally 17.2 tells us that whatever you do in the patent office, it has to be perfect for you to get the priority. If it is not in order and if you have to make amendments, then things can get post dated. So, post dating of documents is there, post dating of priority date is there. In 17.1 we saw the priority being post dated based on a provisional. 17.2 is on post dating, it includes specification, document, drawing, post dating documents. Section 18, powers of a controller in cases of anticipation. We saw that under section 12 and 13, the controller can direct the application to be examined by an examiner, and under section 12 it is stated that the examiner shall make a report on various things, and one of the thing that the examiner will make a report will include the results of investigations made under section 13. And we saw in section 13 the examiner can make a report on anticipation by previous publication or by prior claim, and we saw the instances in which the report can cover cases of anticipation. And when we talk about anticipation, we are only talking about the first requirement in patentability, which is novelty. So, when we say something is anticipated, then we mean that it lacks novelty. Novelty is not there. The fact that the invention has to be new is not satisfied. So, in section 13, the examiner can look at any previous patent, any patent that is granted earlier, and which would mean any claim that is granted earlier. So, prior claiming is covered in section 13. Section 13 also covers prior publication. So, in section 13 there are two kinds of documents you can look at. One is an earlier filed patent application or earlier filed specification which will have a claim. So, when there is a claim that overlaps with the present claim, we call it prior claiming. The claim was already claimed in another application. If you are mapping the invention with any other disclosure, like a disclosure in a scientific journal or in a textbook or in a review article, then we call that prior publication. So, prior claiming is where the invention is claimed in another patent specification, so that you can match one claim with another, whereas prior publication is you do not actually map a claim within another claim, because that disclosure may be in an other document. It may be in a textbook, it may be in a scientific review, it may be in a journal article. So, when that happens, we call it prior publication. So, 13 covers both these instances. It includes prior claiming and prior publication. Publication we understand as a non-patent document. In prior art search, we do a non-patent search, non-patent literature, whereas patent literature or patent search is what covers prior claiming. Now, 18 tells us that 18.1 states that where it appears to the controller that the invention so far as claimed in any claim of a complete specification. Now, this language often repeats itself in various parts of the Act. Invention so far as claimed in any claim of a complete specification, which just means what is claimed. Okay, we are talking about the claim. Some objections may come on to the descriptive part. For instance, objections under section 10 may come to the descriptive part. The claims are not fairly based on the description. But wherever you see this language, invention so far as claimed in any claim of a complete specification, we are just talking about the claims. It just means claim. Where the claim has been anticipated, you can substitute that entire statement, invention so far as claimed in any claim of a complete specification, with the word claim. Okay. Where a claim or what is claim has been anticipated in a manner referred to in clause A of subsection 1 or subsection 2 of section 13, he may refuse the application. 13.1 talks about documents that are in the nature of a complete specification, and 13.2 talks about any other document other than those mentioned in subsection 1. So, we mentioned this, there are two categories of documents in section 13. 13.1 talks about complete specifications where you can do a claim to claim mapping, and 13.2 talks about any other document, which could mean scientific journals and other kind of non-patent literature. So, 13.1 talks about patent literature, 13.2 talks about non-patent literature. Now, 18 says if a claim is anticipated, then the controller may refuse the application. So, very clear cut said, if the controller finds that the claim is anticipated either by an earlier application or by some non-patent literature, he may refuse it. When the controller raises an objection, the applicant can do two things. One, he shows to the satisfaction of the controller that the priority date of the claim of his complete specification is not later than the date on which the relevant document was published, to show that his priority is on the same day or before. If it is the same day also, the controller will allow, or it is before the date of the prior art document, because anything that is published after my application cannot be used as a priority document to challenge my application. It cannot be used as a prior art document. The second thing, he amends his complete specification to the satisfaction of the controller. Now, A and B largely gives the options that are open to an applicant. The applicant's first option is always to convince the controller. Only if the controller is not convinced will he want to amend the application. No applicant would want to amend it at the first instance. He would try to convince the controller to say that. How does that convincing comes? Because here it says shows to the satisfaction of the controller. Now, this involves claim interpretation. One, the applicant can say that the scope of the document which you have cited as prior art, it has to be interpreted this way. If it is interpreted this way, my invention will not fall within the scope of it. One way to do that. Second, if you have a priority document earlier to the date of the prior art, then you can say that, say for instance, you had exhibited your invention in an exhibition, in a technical exhibition. There are provisions in the Patents Act which allows you even after public display to file an application within 1 year. But that information of your public display and the fact that after public display you filed an application within 1 year is not there to the controller. The controller just merely cites a prior art, but if you are able to show that before that you had actually disclosed in a public display, or you had disclosed something what we call transactions of a learned society, there are various protected categories of anticipation. Then you are able to convince the controller that that disclosure was actually a protected disclosure, and because it was a protected disclosure, you are entitled to claim priority from that day onwards, because you made a disclosure which was a protected disclosure and you were able to follow it up with an application, or you made an application abroad based on a priority document filed abroad and you are claiming your priority from there. In all these cases, if you can show to the controller to his satisfaction that the application that is filed is actually not hit by the prior art, either by interpreting the claim and saying that this what is claimed is different from what I am claiming, or by showing that you have a valid reason for being before the date of the prior art. So, either way, either by interpretation or by showing that your specification is not later than the date on which the relevant document was published. So, under 18(1)(a), the applicant's endeavor will be to show that the priority date of the application is earlier than the prior art. Now, assume that the applicant is not able to demonstrate there is a prior art much ahead in time, and the applicant is not able to show that his priority, he didn't know about it. He found that the application was anticipated by an earlier prior art much ahead in time. Then the option open to him is he can amend his specification to steer clear of the prior art. If the technology covering the patent allows him to make an amendment, and if the prior art also allows him to do that, then he may amend the specification to the satisfaction of the controller. Many a times people just narrow down the scope of the invention in order to get a grant. There may be difficulties in enforcing that patent, but nevertheless the patent officer's concern is there is a prior art, we cannot grant you. If you narrow down the scope of your invention, we may be able to grant you, and they may get a patent granted just for that narrow claim. So, that is the second response. If you are not able to demonstrate to the controller that your priority date is before the date of the prior art, the next option is to amend your specification. So, A and B under 18(1) tells you the two responses to anticipation. The two responses to anticipation is, one, to show to the controller, to satisfy the controller that the priority date is not later than the date on which the relevant document was published. If that is not possible, then you try to amend the specification to the satisfaction of the controller. So, these are the only two ways in which you can get over an objection of anticipation. 18(2), if it appears to the controller that the invention is claimed in a claim of a complete specification referred to in clause B of subsection 1 of 13, he may, subject to provisions hereinafter contained, direct a reference to that other specification shall be inserted by way of notice to the public in the applicant's complete specification, unless within such time period as prescribed. The applicant may do either of the two things. He shows to the satisfaction or he amends the specification. Now, here this provision dates back to 13(1)(b). Now, 13(1)(b) is where a claim is anticipated by an application for a patent made in India and dated before the priority date. So, if there is an application made before the priority date and the application anticipates the present application, then the controller has an option of directing a reference to be made to the other specification. This is called a reference, and the reference only operates where there is a pending application, because in 13(1)(b) we know that it is a case where the anticipating claim is in a complete specification that was published on or after the date of filing of the complete specification, applicant specification, being a specification filed in pursuance of an application for a patent made in India and dated before or claiming the priority earlier than that date. So, though it was published on or after the date of filing, its priority was before the priority of the applicant's application. So, we understand that in this case it was not a document that was already there. The day I filed it, it was not there, but it was published either on the day I filed my application or soon after I filed my application. So, there is no way I could have known about that application at all, because the day I filed it, it got published. Most of the time I would have taken the printout, or even if it's e-filing, I would not make a prior art search on the day on which I am filing. My prior art search, everything would have been done earlier. The day on which I file or soon after I file, it gets published. But it was pending all the while. But its reference was to an earlier date. The priority was to an earlier date than mine. So, there is no way me as an applicant could have checked or could have known about that prior art, because it got published the day I filed or soon after I file. In such cases, the controller may allow for a reference, because this is not the fault of the applicant. He did not know about this. So, the idea of a reference is that to give notice to the public that the earlier application, which the applicant did not know when he filed, covers or anticipates, it is a reference, but the reference can be damaging, because then the earlier person can come and sue for infringement and say that you have filed a similar invention as mine. So many other issues can come, but an applicant can again get over that. Again, two conditions: shows to the satisfaction of the controller that the priority date is earlier, or he amends to the satisfaction of the controller. The same two options are there, but here the only difference is the day on which the applicant filed the application, he did not know about the earlier prior art. It was published on that day or after his filing. In such cases, the controller can insert a reference, but the reference can be avoided if the applicant can show to the satisfaction of the controller that the priority is earlier, or the applicant amends the complete specification. So, when he amends the complete specification, again the reference is avoided, because if the scope of the prior art is covering certain things, the amendment, if it gets over that objection, there is no need for a reference. So, there is a power for the controller to insert a reference, and it comes under section 13 1b, and the power is confined to cases where an application got published on the day in which I filed my application or soon afterwards. So, it only covers situations where the applicant could not have seen that prior art, because the day on which he filed, it got published, or after he filed, it got published. So, this is what we call prior art that was about to be published, or prior art that was in the dormant mode. The prior art was already there, priority was already there, but it is in the dormant mode. We know that there is a dormant 18-month period where things need not be published. During that time, there could be prior art that props up, which nobody can search. And there is a danger in patent law, because that whatever is filed and not published for 18 months can still be prior art that affects you, and there is no way you can know. The controller can add a reference if it comes to know, because it was not known to the applicant. And if you want to avoid the reference, you can demonstrate to the controller that your priority is much earlier, or you can carry out an amendment. 18(3), if it appears to the controller as a result of investigation under section 13 or otherwise that the invention so far as claimed, that is the claim has been claimed in any other complete specification referred to in clause A of 13(1), or such other complete specification was published on or after the priority date of the applicant's claim, then unless it is shown to the satisfaction of the controller that the priority date of the applicant's claim is not later than the priority date of the claim of that specification, the provisions of section 2 shall apply in the same manner as they apply to the provisions published on or after the date of filing of the applicant's complete specification. This just says what applied to 13(1)(b) can also apply to cases where 13(1)(a) is also mentioned. So, the situation is similar, that if something that has been claimed is covered by a complete specification mentioned in 13(1)(a), and 13(1)(a), we saw that 13(1)(a) is all the applications that were filed in the old regime, that was in the 1911 regime. because in 1911 Act came into effect on the 1st of January 1912. So, any application that was published before the date of filing of the applicant's complete specification, in any specification filed in pursuance of an application for a patent made in India and dated on or after the first date of January 1912, which means all the applications made under the 1911 Act could also anticipate. If it appears to the controller that the results of an investigation that an application made under the 1911 Act anticipates the invention, or such other complete specification was published on or after the priority date of the applicant's claim. This may not happen at all, because an application that is filed, and understand that this provision came into effect in 1970. The Act was passed in 1970 and it came into effect in 1972. So, all the applications that were filed before this provision came into effect, say in 1969, if an application was filed, it was filed under the 1911 Act. This covers the transition period. Application that is filed in 1969, Act was passed in 1970, came into effect in 1972. If the complete specification was published on or after the priority date of the applicant's claim. So, similarly, just how we saw there could be applications that are filed or that get published after you file, similarly there could be applications that are published after you file the application or after your priority date, but this is under the 1911 Act. In 1972 the new Act came into effect and you file your application in 1972 claiming priority on the date of your filing. There could be applications filed under the 1911 Act which are still pending, but which get published on or after your priority date. Same rule applies. The controller can insert a reference, just how it happens in the patent office today for the 18-month period. This is just the regime under the 1911 Act, because 1911 Act was replaced by the 1972 Act. It's the same principle, is the same. But it was in under two different acts. When we talk about the 18-month period, it is under the same act, correct? 1917 Act, there is an 18-month period. I file an application, on the day I file the application, the other person's application is published. Here it is under two different acts. Try to understand, that is the only difference. The two different acts are the 1970 Act and the 1911 Act. So, if you file an application under the 1970 Act, and there was a pending application under the 1911 Act which got published on or after the priority date of your application. Are you able to understand this? Though it was filed under the earlier Act, it is published after the date of your priority, out of the date on which you file. Let us assume that your priority is the date on which you file. In such cases, again the controller can insert a reference. So, in the earlier provisions, the reference was for a case where something was lying dormant in the 18-month period. Here the reference is for something filed in under a different act, because the 1911 Act was replaced by the 1970 Act. So, if you file an application under the 1970 Act and there is an application filed under the 1911 Act, say in 1969 or 1968, which is still lying dormant, after your priority date it gets published, the controller can ask for a reference to that act. So, the earlier provision under 18(2), if somebody asks you this question, what is the difference between the reference made under 18(2) and 18(3)? Both talk about reference to be made by the controller. The difference is that the reference under 18(2) is to the same act, application filed under the same act, whereas the reference under 18(3) is to an application filed under the earlier act, which is the 1911 Act. And we get all these information. If you look at 162, if you look at the last section in the Patents Act, repeal of Act 2 of 1911. So, the earlier act, the Indian Patent and Design Act, is hereby repealed. So, this act came to replace that act. So, the question arises, one day before this act came into effect, applications were filed under that act. So, that is why when you see, this is not clear. If you see the provision of section 13(1), they just say that all applications that were filed on or after the first day of January 1912. That is all it says. It does not say the Indian Patents Act, Patents and Design Act 1911, but we understand, because we know the scheme of things, that the Indian Patents and Design Act 1911 came into effect on Jan 1912. Okay, we understand that. So, the difference between 18.2 and 18.3 is that 18.2 refers to instances under the same act where within the dormant period where the applications are unpublished, the day on which you file an application, the prior art is published. Controller can ask for a reference. In 18.3, the day on which you claim your priority, the prior art is published, but the prior art is under the 1911 Act. This is the only difference. Rule 31 tells us in what form that reference can be made. Rule 31, form of reference to another specification. When in pursuance of Rule 30, the controller directs that a reference to another specification shall be inserted in the applicant's complete specification, such reference shall be inserted after the claims and shall be in the following form. Now, a question can be asked under section 18, if the controller makes a reference, where will you find it in the specification? The reference has to be made after the claims. So, where is the position a controller's reference under section will be? It will be after the claims. And what is the form of reference? Form of reference is this: a reference has been directed in pursuance of section 18(2) of the Patents Act 1970 to the specification filed in pursuance of application number so and so. So, then that number is given here.